Good evening, everybody, and welcome to yet another webinar organized by the City Law School and its Institute for the Study of European Law. I am Panos Koutrakos. I am the Professor of EU Law and Jamon, the Professor of EU Law at City Law School, and it is a pleasure to welcome you all. We at City do not let such minor events as lockdowns and travel bans prevent us from discussing what is new and interesting and relevant. And the trade and cooperation agreement between the UK and the EU is all of these things. The Council's decision on the signature of the agreement describes it as of, and I quote, an exceptional and unique character. It is about disentanglement. It is about managing new obstacles. We also know that the agreement is but a part of a process which has been ongoing and which will be ongoing for some time. It marks a specific development for the management of Brexit, but leaves a number of issues open. I'm delighted to introduce my colleagues at City Law School to discuss these and other issues tonight. And in fact, it is a testament to the school's expertise in European law that we should be in a position to cover all these aspects of the agreement in-house, as it were. Some housekeeping. Each speaker will speak for 10 minutes. Once all speakers have spoken, I shall open up the floor for discussion. Please feel free to type your questions on the Q&A box. I shall pick up questions and a member of a panel will address them. If your question is addressed to a specific member of the panel, please make this clear. While I may not promise it, I shall do my very best to ensure that we answer all your questions. Let us start now. We have 5 presentations. Our first presentation is by Dr. Enrico Bonadio, who is a reader at City Law School. And he's going to talk about the intellectual property aspects of the TCA. Enrico, on to you.
Thanks, Panos. I'm going to share my screen. Now you should be able to see the slides, right? Okay, good. Thanks. Okay, so in my presentation, I will briefly look at the IP aspects of the TCA, of the Treaty and Cooperation Agreement, but not only at this treaty, because of course this treaty needs to be examined with the withdrawal agreement and the unilateral steps taken by the UK government, right? So in the TCA, there is an IP chapter, same broad structure as other IP chapters in other trade agreements that the European Union has entered into with other countries, Japan, Canada, Korea. There are general provisions on commitments to the TRIPS agreement, the Berne Convention on Copyright, the Rome Convention on Phonograms, WIPO treaties. There are some minimum standards of protection, business as usual in this kind of agreements, national treatment clause. And as I said, we need also to look at the withdrawal agreement and at unilateral steps taken by UK to have a holistic, broader picture of the IP aspects of the new relationship. And also, we need to take into account that the case law of the Court of Justice of the European Union with reference to IP will be retained in UK, the case law until the 31st of December 2020, of course. Then the courts of the UK will be free to interpret, to decide cases by relying on UK law only. So let's start with the trademarks and designs. These have been steps taken by the UK. So what the UK has done is to clone the existing EU trademarks and the EU design rights. So there will be no more effective, of course, for the EU trademark you design in the UK, but those EU trademarks and those EU design that, you know, until the 31st of December 2020 have been transformed in UK comparable rights, trademark rights, or design rights, or unregistered design rights. Another the key issue in the negotiation was geographical indications. The TCA does not provide substantive provision on geographical indications. So what happens to the European geographical indications that once were protected in the UK? I'm talking about feta cheese, Parmesan cheese, champagne wine. Well, the UK here has taken the unilateral step of providing a protection which is comparable again to the previous one. So instead of having on the right, you see the European PDO, protected destination origin, the European protected geographical origin, you have a UK GI, designated origin, geographical origin, or UK protected. So again, there is a kind of mirroring the previous protection. It remains to be seen whether the scope of protection of these titles will be so broad as the one which is usually guaranteed in the EU, also as a consequence of very protective, protection given by the Court of Justice, for example. It remains to be seen. What about domain names, right? The .eu, which is the internet address of websites, commercial websites. Well, the domain name, the EU domain name, can be owned only by EU companies or individuals. So UK businesses, for example, will not be able now to own the .eu domains. You may have heard in the media the news about the live.eu organization losing the EU domain. That's a consequence, of course, of leaving the EU. These domains cannot be owned by UK individuals and UK businesses. As far as patents are concerned, there is not much change because the European Patent Convention is not an EU instrument, so it will continue to apply in the UK, and so there is not much change apart from the UPC, the Unified Patent Court. Before Brexit, we know that London had been nominated as the UK branch for pharmaceutical inventions. Of course, after Brexit, this will not happen. But there is not much change as far as patents are concerned in general, because the European Patent Convention continues to apply to the UK. A very important aspect is the IP exhaustion, right? IP rights are exhausted once the first sale of the IP protected product happens in the European Economic Area. Well, now, after Brexit, after the 31st December, original goods sold in the United Kingdom for the first time by the IP owner cannot freely be resold in the European Union, because there is no exhaustion in this direction, at least. And also in the island of Ireland, this happens. Very, very strangely, the Northern Ireland Protocol has not incorporated a rule on IP exhaustion. So, in theory, goods original goods purchased in Belfast from the trademark owner cannot be resold by the trader in Dublin. So they can, but there is a risk of an IP infringement action that could constitutes a quite important barrier to trade in Ireland, in the island of Ireland, between the Republic and the North, and between UK and EU more in general, especially from the UK to the EU, not the other way around. What about copyright? There are, as I said, the provisions from the Berne Convention, which are enshrined in the TCA, but the way European courts and UK courts may in the future interpret certain bits of copyright laws, I'm thinking about the originality requirement. Historically, the way the UK courts and at least before Infopac, before 2009, the way the UK courts and European courts interpret the originality requirement was different. And we may now go back to such difference, with the UK courts stressing again the famous originality rule, skill, labor, and judgment. So there might be differences in this specific regard. Also for copyright protection of designs, right, in the future. Now we have seen the European Court of Justice last year or 2 years ago said that, you know, designs now can also be protected by copyright, but the UK in the future, the UK courts might adopt a different stance. Also with reference to another right given by copyright, the communication to the public. I mean, the same Court of Justice of the European Union has interpreted the communication to the public protection in different ways, depending on the specific facts. So it might be possible that the UK courts might interpret this bit of copyright law differently. Orphan works in the field of copyright. There was a directive in 2012. It has not been incorporated. I mean, the main principle of that directive have not been incorporated in the TCA. So the status of orphan works at EU level will not count in the UK. So there will be different regulations here. Databases, there is nothing in the TCA. The UK has taken unilateral steps to replicate an identical right, a sui generis right for databases. But again, UK entities will not be able to own the sui generis rights in the European Union because the ownership is reserved to EU subjects. But I don't think this will be a very much important, gap because I mean the database directive, this database right has not worked so well in the EU, and so I don't see much problems here. What the UK has, I mean, and it is specified in the TCA, and the UK is keen, clearly, to keep it, is the resale right for works of art. So basically, this is a royalty which must be paid to visual artists, right? Once every time their artworks, for example, a painting, is sold in the market by professionals like auction houses. Well, there is a right remains. And if you see this data is important because since 2006, the Copyright Collecting Society in the UK has paid out almost 100 billion pounds in royalties to artists. So it's something that UK artists have benefited from. So they will continue in the future. What the UK will not introduce for sure is the so-called publisher's right. There is nothing in the TCA, and the government has said that they will not introduce it. This is again a royalty, a fee, which is channeled to publishers, right, of newspapers, once their news are used by so-called news aggregators, right? So the UK will not implement this. This publisher rights was contained in the recent digital single market directive. The UK will not do that, which means that probably news aggregators, right, which use massively content from newspapers without paying, well, such news aggregators will find a good business probably in the UK because the UK has not adopted these publishers' right. And then in the future, what will happen in the future with the creation of new IP rights? We have seen in the latest decades, years, the EU has created sui generis right, as it has done so with the databases, with the publishers' right. It might continue in the future, right? The EU might continue introducing new sui generis rights. Well, the UK will not be bound by those new rights. So we might see further divergence in this specific case. Let me conclude with my last slide, which is about the profession, because IP attorneys, and particular trademark attorneys, UK trademark attorneys, have lost their ability to, of course, assist clients for example, the filing and prosecution of EU trademarks. I mean, that was a very good business for UK trademark attorneys, and probably the big law firms, the big firms, will have their own correspondence in the European Union, but it might be a blow for the small ones. Thank you so much. Sorry if I am a bit over the time.
Thank you very much, Enrico. It was extremely interesting and comprehensive. I mean, you managed to speak about a lot in a very clear and concise way. Before we started, I'd been thinking how long it would take for Northern Ireland to be mentioned. It took 5 minutes. I'm sure we shall return to this. Our next speaker is Professor David Collins, Professor of International Trade Law, and he's going to speak about the investment provisions of the TCA. David, on to you.
Okay, thanks, Panos. So the investment provisions in the TCA are rather limited. Investment is bundled together with services in one chapter, and it's not really appropriate to describe them as investment protections, as you might see in a conventional bilateral investment treaty or even a free trade, an investment chapter in a free trade agreement. They're really designed to be liberalization provisions, which is encouraging. And I think to a degree, they may achieve that. So when we think about liberalization, what this really means is eliminating barriers to new investment rather than protecting existing investments. So just in terms of, I guess, first of all, what's missing from the investment provisions of the TCA, and again, I would say the protections are quite limited. There's no fair and equitable treatment principle, which you would expect in an investment treaty or an investment chapter of a free trade agreement. There's no full protection and security principle, also pretty standard in the average investment treaty. And there's no guarantee against expropriation without compensation. This is a classic feature of an investment treaty. So these are fairly glaring omissions in the sense that if this was a treaty that was aiming to protect investment, it would be massively deficient. There's no umbrella clause. These tend to now be missing in modern investment treaties. So that's maybe not quite as significant. There isn't even a definition of investment, which I think is perhaps also quite unusual, especially for an instrument of this size, for a treaty that's this massive. And perhaps most controversially or most interestingly for commentators, there's no investor-state dispute settlement. Now, given that the treaty doesn't provide protections for investors, the omission of investor-state dispute settlement is perhaps not surprising. This is where investors have a direct claim, a direct procedural mechanism through which they can bring claims against host states. So it's not in the TCA. Now, this is in keeping with some recent treaty practice of both the UK and the EU. We don't see ISDS in the UK-Japan agreement. And in the recent EU-China agreement, it's also missing. However, interestingly, the new EU-China agreement mentions that the parties will consider and negotiate potentially for the inclusion of investor-state dispute settlement. And they actually mentioned by specific reference to the multilateral investment court project and investigations undergoing through UNCITRAL. The fact that that language is missing from the TCA suggests that there probably isn't going to be investor-state dispute settlement in this instrument in the future as it adapts and changes over time. And in one sense, that's maybe a reflection of the parties' faith in each other's judicial systems. They don't think that a specialized mechanism is necessary. The domestic courts are sufficient, and I think that's perhaps a good sign. Now, moving on to what I think are some of the other positive indications from this agreement in terms of achieving liberalization. There is a national treatment obligation, which requires that there can be no discrimination against investors from the other party based on nationality. And importantly, this extends to the establishment and operational stage of an investment. So I guess you could say pre-establishment and establishment. Pre-establishment means before the investment has entered the country, and before it's set up, sort of, but it's in preparation. And it's unusual that the national treatment would be extended to the pre-establishment stage. That's not common in free trade agreements. You see it in some of the deep ones, like the USMCA, for example. So this goes quite a bit further than an average investment agreement. And this is really about liberalization. In that sense, it's almost as if investors from the UK and from the EU have a right of establishment, a right of entry, almost as in the old days, in the pre-Brexit days. However, there's massive carve-outs for this. There's a long annex that goes more than 100 pages of the reservations, the exceptions from these obligations, with lists for each EU member state and so on. And they're pretty lengthy. You would really need to come to terms with that to get a sense of what this actually means, this national treatment commitment. Encouragingly though, given that the default is that there's national treatment for everything, and it's framed as a negative list, here's the sectors where it's not allowed, that is seen as being conducive to liberalization. It's more transparent and predictable, and it also enables investments in new areas, maybe new technologies, to presume that they're de facto allowed to enter, since they haven't been listed as reservations. So there's also a most favored nation provision, which also extends to the establishment and post-establishment stage. The TCA investment chapter also contains a prohibition on performance requirements. This is very important because it allows investors to enter and operate within the foreign country without being required to fulfill things like local content requirements or export requirements. Now, that would be allowed anyway under the WTO TRIMS agreement, but this actually goes further. This is quite a lengthy prohibition of performance requirements provision. It's quite comprehensive, and I think that's encouraging because we would normally see performance requirements, conditions on entry as operating as distortions. Now, that's of most utility to manufacturing investors. And in the case of investors generally, including services-oriented investors, there's no requirement of specific nationality for directors of companies. And that should also be conducive to the liberalization and movement of investment across borders. Again, that is subject to reservations that can appear in the annex, and you need to look through that in 100 pages. They're pretty comprehensive, so it's they're pretty extensive. So it's not as liberal as we might hope. I should say also that there is a free transfer of capital and currency provision. This is standard for investment agreements. This allows profits to be sent back home. And this is pretty essential. You would expect this in an investment agreement. And we see it there, which is good. And lastly, there are standard WTO style general exceptions. So this covers things like life and health and public order and so on, which are pretty standard for investment treaties. So nothing really exciting there. The last interesting provision, and I could have spent my whole 10 minutes on this, but I won't, I'll just mention it briefly, are the level playing field obligations insofar as they apply to investment. This is really framed as what you might call a standard non-regression clause, in which the parties promise that they won't lower their standards, their regulations in the area of the environment and labor with a view to attracting investment and also trade. But for the purposes of my discussion today, just looking at investment. So this is really, it's not a right on the part of the investor, it's a right of the state, of the parties to the treaty, to take action if they think that the other parties trying to undercut them by lowering their standards race to the bottom to distort investment. Fairly standard. There's a lot of the non-regression clauses in free trade agreements. The mechanism in the TCA is completely groundbreaking. There's nothing like it. It's incredibly innovative, and there's been so much written about it already. I've written a few things, and there's a lot of discussion going on about how it's going to play out procedurally in terms of what's required. But I would say my reading of it is it was framed in incredibly narrow language. There's a requirement of a material impact on investment, and the standard of materiality under international law is a very high one. It really talks about a fundamental threat to the significance of the agreement. And there's even language that references strict necessity. And necessity is already such a hard standard. When you see strict necessity, I think it really gives you a sense that it would be a very egregious change in foreign direct investment flows, in my view, that would trigger a review under the level playing field obligations. That's my sense. And it also talks about there needs to be evidence, not remote conjecture. So I would say that, at least in terms of how it affects investment, the level playing field / rebalancing, and rebalancing envisage that the parties can impose tariffs as a remedy. So it's really its own kind of trade remedies. I think it's very narrow in the TCA. I don't think it was intended to be used with much regularity. And just as another point, just evidential in an evidential sense, I think demonstrating the counterfactual, what would the investment flows have been had the standards not been lowered, whatever that means, whatever it means to lower a standard, I think would be exceptionally difficult. And some of the WTO subsidies cases touch on or certainly reflect this evidentiary difficulty. So that's it. I will stop there. Thank you very much.
Thank you. Thank you very much, David. You spoke about something which is topical, interesting, and extremely complex. Somehow the last couple of years, we've all been talking more about international trade law, and we are bound to be talking a lot more about this in the near future. Our next speaker is Dr. Jonathan Echevarria Fernandez, who is going to talk about an area which some might say attracted disproportionate attention to its actual economic significance. As I said, some might say that. This is fishing. So Jonathan is going to talk about the consequences of the agreement for the fishing industry. Jonathan, over to you.
Thank you very much, Panos, for your kind introduction. I'm going to share the screen so everyone can see better my presentation. 1 second, please. It should be working now. Yes. So here we go. So basically, what I'm going to introduce is one of the most sticking points during the negotiations. And as you know, the EU and the UK had several concerns regarding the amount of catch available, also the species that are available during the until 2026, exactly when the period will be reviewed and all the consequences will be assessed, and the total catch will be subject to a further negotiation. So there are several concerns from both sides regarding this topic. The EU negotiating part got the numbers wrong, as far as we know, and that's why we had a very delayed approval or agreement reached on the 24th of December. So without any further delay, I will start with the first part of my presentation. So even though the economic importance of sea shipping is relatively small in the UK, and it accounts for only to the 0.12% of the GDP and employs 12,000 people, it has been used as a central claim of the campaign to leave the EU since 2016, as a way of retaking control of the waters that inherently belong to the UK, and which have been thought to be misused under the common fisheries policy set up by the EU by mismanaging stocks and incentivizing overfishing in British sovereign waters. The fisheries industries of both parties have become deeply integrated, resulting in European fishermen using British waters and vice versa. Moreover, the great majority of the UK fishing production is exported to the EU. And the EU was concerned that the loss of fishing rights in British waters would harm its coastal communities. To avoid that risk, its objective was to uphold union fishing activities by maintaining a continued reciprocal access, establishing periodical total allowable catches, and organizing a joint system of control and inspections. And the UK's position was based in a desired annual negotiation with the EU for the allocation of quotas according to a different method called zonal attachment, which is based on whose waters fish inhabit. And the system could potentially give the UK fishing boats between 14 and 55% points of the total catch in British waters, depending on the species. With the withdrawal of the UK from the EU, the UK recovered full sovereignty rights over its waters, which means that the power of decision over the access, exploration, exploitation, conservation, and also the management of the British waters and the living resources that habitate in it is no longer shared with the EU. Sorry. However, both parties agree that this power should not be unlimited, but it must be exercised in accordance with the principles of international law. On one of the clearest examples of these limits is the one posed by the environment and conservation of the marine resources. Bearing in mind its importance, both parties undertake to base all their decisions on the best available scientific advice, mainly provided by the International Council for the Exploration of the Sea, called ICES, comply with the relevant international instruments that regulate the environmental component of the fisheries, among them the Food and Agriculture Organization agreements, the FAO, to promote a good fisheries governance, sustainable fisheries and aquaculture practices, and trade in fish products. And they also agreed to combat illegal, unreported and unregulated fishing. After the 31st of December, so by the time that practically the agreement, the TCA, entered into force, that's the 1st of January, EU member state flagged vessels have no right to fish in the UK waters until a fishing license is issued to them and vice versa. There is an adjustment period that will last from the 1st of January 2021 until the 30th of June 2026. That's the period I was referring to at the beginning of my presentation. And this is the moment until when fishermen will be permitted to continue to access the waters of the other party. However, the right to access is now to be exercised according to the determination of the total allowable catches that will take place in annual consultations. And finally, the TCA provides for the creation of a specialized committee on fisheries, which maintain objectives, in which its main objective is basically to provide a forum for the UK and the EU to discuss and cooperate on a variety of fisheries-related affairs, such as to coordinate the annual fisheries consultations and provide a forum for consultations regarding the compensatory or remedial measures. In case of non-compliance by the other party of its obligations, the complaining party must notify the specialized committee on fisheries with the aim of reaching a mutually agreeable solution. And depending on the economic and societal impact of the alleged failure, the complaining party might suspend in whole or in part the access to its waters and the preferential tariff treatment granted to fishery products, suspend the preferential tariff treatment of other goods, or suspend in whole or in part the obligations under heading 1 of the TCA regarding trade. So the complaining party must file for an urgent arbitration procedure in which the adequacy of the measure enforced will be judged. For more information about fisheries and Brexit, and if you want to participate in the Higher Education and Innovation Fund project I'm running, you have more information here, and thank you so much for your attention.
Thank you so much, Jonathan, both for providing the detail we need in order to appreciate what has been going on in this area, but also for highlighting the thread that brings together this specific solution to the greater sort of narrative of sovereignty, which we see underpinning the entire agreement. Before I move on to our next speaker, may I ask all of you, if you have any questions, please you do not have to wait until the very end of the presentations. Feel free to type your questions in the Q&A now, and then we will pick them up and address them at the end. Our next speaker is Ellen Fahey, Professor of Law at City Law School and Jean Monnet Professor of Transatlantic Relations. She will talk about digital trade and data. Elaine, over to you.
Super, thank you very much, panelists. I suppose digital trade is an extremely interesting part of the Brexit negotiations for a number of reasons, principally because if you were following it in any degree, you would have realized that it wasn't at all in any way interesting. In fact, it was barely discussed, barely reaches any kind of level of significance until March 2020. And in the end of the day, it's a very short, slim chapter on digital trade that you will find, and it's located in the meat of the TCA in part 2 in the digital trade section. But quite interesting enough, it sits alongside services, which, as we know, is an extremely thin part of the FTA generally, and is, as a result, WTO law, international economic law is mired in the question, what is digital trade? Is it a good or a service? It's impossible to buy a child's toy or a smartwatch nowadays without having to sign up to some kind of app or service. And so as a result, what's interesting about the Brexit agreement is that it adopts very modern terminology, but it's also very American style terminology, digital trade. And unlike, for example, the EU's agreement with Japan and GPAM, where we saw e-commerce embedded with services, we see here it stand apart. The other very interesting thing about the TCA is just how much data is mentioned in it. So not just digital trade matters, but also data matters. So for example, passenger name records, basically a security related issue, gets a really detailed, long provision of a trade agreement, something that I haven't seen to this degree before. This institutionalization of data is a really big issue here. What is also very important is to say that the TCA adopts a very broad, liberal definition of trade generally, digital trade, which is trade enabled by electronic means. And there's a very nice definition of digital trade, its relationship to services in Article 5 thereof. But as I said, it's not necessarily particularly interesting because it's such a slim or skinny trade agreement when it comes to services. Now, there's lots of very other interesting modern provisions of the TCA, for example, relating to the conclusion of online contracts, online consumer trust, open source data, and so on. I'm just going to focus on a few because of the nature of time. But the really interesting thing nowadays about digital trade is not digital trade at all, but rather about data flows and privacy. And the big elephant in the room is the place of the GDPR. And just after the EU's adoption of the GDPR a few years ago, there was an incredible dispute between the institutions as to how to deal with electronic commerce or digital trade going forward with the EU's GDPR. And so the EU developed the so-called horizontal strategy on data flows, the model clauses, in 2018, which have been forwarded on to all of its negotiation partners from Australia to Chile, Indonesia, Mexico, New Zealand, and so on. And it's also been put into the EU-Japan negotiations, essentially into the EPA to renegotiate those clauses. The EU has also uploaded this text to the Joint Initiative on E-commerce. And I don't know how your eyesight is. Mine is extraordinarily strange to the point that I thought I was a previous speaker 2 speakers ago. But if you can see this at all, you'll see on the left there's an Article A on cross-border data flows, which the EU has never had in its trade agreements, where the EU commits to this. And then there's a clause after this with several sub-clauses 4. And the second one is the really important one, and that says that there shall be no bad data localization. You shall not require parties to store or process data in their territory. And the EU, of course, after the GDPR, faced all these accusations about being a localization actor. Then there's an Article B that says personal privacy is a fundamental right, clause, first clause, second clause, that there can be provisions to have cross-border transfers of data. There's also an Article X providing for regulatory cooperation in digital trade. So goes the theory, so goes what the EU was designed to transmit to all of its partners. The Brexit agreement is all the more interesting. So Article 6 of this particular part of this chapter provides in Article 6 for cross-border data flows verbatim, the model text, which we have never seen the EU commit to before, but it is all the EU's text, and the UK was looking for CP/TPP language. So you'll see that, you know, the EU says we shall have cross-border data flows and we shall not have any bad data localization. And people say this is very important because there's a question mark just, you know, how much the EU has been pushed to back away from this after its Schrems decision and so on in last year, 2020. The big elephant in the room, though, is Article 7 on the protection of personal data. And you'll see that if you have even keener eyesight than I, or if you have not been zooming far too much, you'll see that the words fundamental rights are stripped out of the first paragraph. And for some reason, personal data is not described in these terms. The second paragraph there of Article 7 is even more interesting. It says, nothing shall prevent a party from adopting or maintaining measures on the protection of personal data, including with respect to cross-border data transfers, provided the law of the party provides for instruments enabling transfers under conditions of general application. Then you have to really squeeze in for a footnote there mentioning conditions of general application, conditions formulated in objective terms, applying horizontally to an unlimited number of operators. I don't know about you, but I think I've read this about 10 times, maybe about twice out loud, and it's an extraordinary mouthful. And this has got the attention of a lot of the member states. There's a lot of pushback against this. And the principal pushback, of course, is against this defundamentalization of privacy. But the main pushback against the second paragraph appears to be this question of why do the model clauses phrase this in positive terms, and this is so negatively worded, and why so differently? And there's a concern here that the Commission is attempting to somehow backtrack away from the Schrems decision, or perhaps some views in more positive terms that this mentions non-discriminatory, non-discriminatory flows of data. This is a good thing. So it remains to be seen what happens this particular clause. There's also a very interesting clause on regulatory cooperation in digital trade, interesting for all the wrong reasons, because it's extremely short and skinny. There's hardly any meat in this. This adopts the EU-Australia text, but it's very far removed from JIPA, the agreement with Japan, or CETA with Canada, where there were lots more areas of cooperation. And the real elephant in the room here is, where is multilateralism? Where is global cooperation, which is a standard part of this? And there's a certain malafidus perhaps to some extent, because of course the EU is very much a global data giant, and the UK is really pushing to become an actor of its own right. Principally, its first actions at the WTO in recent times have been quite interesting. There's very interesting provisions in the final clauses mentioned on the bridging provisions pending the adoption of a UK adequacy decision, which mentions a specified period before this happens, that there can be safe flows of data between the EU and UK. And you'll see the specified period is set out to be either 4 months plus 2 months, but nothing else. So in this period of time, the UK cannot change its laws away from the regime in place. And this all gets rather interesting for a variety of reasons. Sorry, this isn't. Oh yeah. This gets very interesting for a variety of reasons that I'll mention in a moment. If the slide is allowing me to go backwards. Oh, it's not. Okay. Non-cooperation of Zoom. But I'll move on then. A very positive and very interesting part of the TCA are the provisions on cybersecurity, where of course the UK was one of the leading members of the EU in this. And I think it's an extremely positive amount of dialogue, information sharing, exchange, participation that is possible in this particular section. For some reason I have non-cooperation from prior part. Oh yeah, here we go. Okay. Oh, I'm not sure what slide you're able to see from me, but oh, okay. I'll just continue.
It hasn't changed. We're still seeing. Yeah.
Is it cybersecurity? Okay.
Yeah.
Well, I'll just continue in any event. There are two major points I wanted to make. The first is the Partnership Council has a lot of powers in the area of, in a whole variety of areas, but the only, in the institutional provisions, the only power of the Partnership Council, which is specifically enumerated, is actually as to data. And this has raised a lot of concern about the extent to which data has some kind of superordinate type of competence within the treaties. And of course, the Partnership Council's decision-making powers are not binding. So this is, a matter of much importance. But just returning to the adequacy decision issue, this has raised a lot of concern, particularly in the European Parliament. They've just passed a resolution a number of days ago asking the Commission to be very vigilant because of the UK's mass surveillance laws in place as to the grant of this adequacy decision. And in particular, the Renew group of the European Parliament, led by Sophie Netveld from the Libe Committee, has said that at least 4 conditions must be attached to the UK getting an adequacy decision. So just the other day, the Commission has published several thousands of pages of the adequacy decisions, and has specifically said, the Commission specifically said that there are many problematic issues about the UK's legal order. Now, all of this remains to be seen whether or not the Court of Justice's decision on mass surveillance are being taken into account by the member states, or the extent to which the US is watching all of this and wondering whether or not the UK will be granted an adequacy decision. It remains to be seen, but it is a very important thing to know that the UK, in its agreement with Japan, its CEPA agreement, allegedly going so much further than the JIPA agreement, has very much agreed to diverge from EU privacy standards as to the GDPR to the much more economic understanding of APEC CBPR, which the US and China don't look like they're going to join with reference to joining TPP. So it's not particularly clear what is going to happen with respect to the state of data flows in that regard. So I'll leave it there, and apologies for my presentation stopping just at that point.
No, thank you so much, Elaine. I'm sure we will be talking about data for quite some time. Our last presentation is by Dr. Ryan Stones. He's going to talk about competition law. Ryan, over to you.
Thank you very much, Panos. Hopefully you should be able to see my slides. And as we're rather short on time, I'll start my stopwatch as well. Good evening, everybody. I have the pleasure of speaking on the topic of competition policy and the implications of the EU-UK trade and cooperation agreement. Now, I should say at the very beginning what I mean by competition policy, and I'm focusing upon 2 particular things. So firstly, what we'd call antitrust. So enforcement against, on the one hand, cooperation between businesses, particularly through agreements, and on the other, abuses of market dominance. And secondly, merger control. There are obviously other wider competition policy implications from the TCA, in particular with regards to subsidy control and state aid at EU level and the public procurement regime, but I'm focusing upon these 2 because of the limits of time. To understand the TCA and what it tries to remedy, it's useful to go back to how competition enforcement affecting the UK and businesses therein occurred during membership of the European Union and also up until the end of the transition period, so until the beginning of this year. So when it comes to antitrust enforcement against agreements and abuses of dominance, we have a complex mixture of enforcement by the European Commission, in cases affecting the UK, and also UK authorities, principally the UK Competition and Markets Authority, but also the sectoral concurrent regulators. So where there was an effect on interstate trade between member states of the EU, we would have either the Commission doing enforcement, which would have an effect on the UK and markets, or it would be by the UK CMA and the concurrent regulators. And as to which of those 2 levels the enforcement of EU competition law happened at, this was decided through the mechanisms within the European Competition Network as to who was best placed to bring the potential infringement to an end. At the same time, where the jurisdictional requirement for EU competition law wasn't met, so there was not an effect on interstate trade, The UK CMA would be enforcing the Chapter 1 and Chapter 2 prohibitions of the UK Competition Act 1998, which are functionally and textually pretty much identical to the relevant parts of the TFEU at EU level. When it comes to merger control, we see the similar divide between EU and UK level affecting business decisions within the UK. So if there was a community dimension to the proposed merger or acquisition, then the one-stop shop principle of Regulation 139/2004 would come in. So the European Commission would have exclusive jurisdiction to review that transaction and decide whether to prohibit or permit. And if the community dimension requirement for the EU-MR was not met, then the CMA may be able to review the transaction, whether prospectively or voluntarily afterwards, under the Enterprise Act of 2002. So that's how things stood at the end of 2020. Whereas from the beginning of 2021, all of the EU stuff is understandably stripped away. So now we have a completely independent UK competition policy, where the UK CMA is applying the Competition Act 1998 to agreements or abuses of dominance, and is also applying the Enterprise Act 2002 to mergers and acquisitions. Now, to ensure that there wasn't too much uncertainty for businesses, a number of changes were made internally with UK legislation. So changes to parts of the Competition Act and rolling over block exemption regulations. And the CMA has updated a number of its guidance documents. But there are still potential frictions there. So now that we have the two separate competition regimes, it is possible that we see going forward parallel investigations by the UK CMA or domestic authorities on the one hand, and the European Commission on the other, with regards to antitrust investigations or merger reviews. Now, aside from the potential for differing conclusions, this has implications for the CMA as well, in terms of its increased caseload, in particular from an increase in the amount of mergers which are reviewed at UK level, which had previously been looked at by the European Commission. And this dual regime has implications for businesses in terms of the resourcing and administrative burden of complying with two different regimes. In terms of doing those investigations, the UK is losing access to the European Competition Network, which is the group of all of the national competition authorities in member states and the European Commission, which had mechanisms for the exchanging of confidential information to coordinate investigations. With regards to private enforcement in the UK, European Commission decisions post the beginning of 2021 will no longer be used or can be used as a basis for follow-on damages claims. And of course, with there being two separate competition regimes which aren't linked in the same way anymore, there is the potential for substantive divergence. So all of these frictions are things which the Trade and Cooperation Agreement could potentially address. When we look at the Trade and Cooperation Agreement, the preamble does give us this high-level commitment to a level playing field for open and fair competition. This is addressed in Title 11, Chapter 2 on competition policy. But as you'll see, this is rather vague. So in Article 2.1, there's a recognition by the EU and the UK that competition is important going forward. When it comes to Article 2.2, there's a commitment to maintaining competition law of those three major areas of enforcement. And in Article 2.3, that there actually will be enforcement of EU and UK competition law by an independent authority. So the European Commission will continue, and the UK CMA and the national sectoral regulators. In terms of the frictions which I identified beforehand, the most important part is probably Article 2.4, which is on cooperation, though again, it remains very high level. So there's a recognition by the EU and UK to the importance of cooperation and a commitment going forward to try and coordinate when they are investigating the same practice, the same conduct or merger. But how is that actually going to work? Well, in Part 3 of Article 2.4, where possible, where permitted by each other's respective law, there may be the sharing of information. Though when it comes to the really important confidential information, that isn't something which can readily happen between the two regimes. And this leads us on to the most important part of Article 2.4, which is the final section. So this is where the UK and EU say to each other, in the future, to ensure that coordination and cooperation can happen effectively in investigations, we're committing to a separate agreement, something to be worked out where we will be able to exchange that important, sensitive commercial information to work together. So really, all we have are some very high-level principles and future commitments to sorting things out for more coordinated enforcement. This leaves the potential for some divergence to happen between the two regimes, and this is divergence that could happen quite soon. So I've picked out a few things just to briefly mention. The number one consideration, I would say, for competition authorities around the world is, what do we do about the big technology firms, the big tech giants? And we can already see the EU and UK doing their own thing in this field. So the EU is working on its proposals for the Digital Services and Digital Markets Act, and the UK authorities over the last few years have done lots of work on the digital economy. In April 2021, the new Digital Markets Unit is going to be starting in the CMA, which will be considering a code of conduct for the big digital players that act as gatekeepers. And when you look at the information coming out of the CMA, it seems to go both ways on cooperation. So on the one hand, the chief executive of the CMA, Andrea Koskeli, in a lecture from the 9th of February, said this digital markets unit looking at these issues is obviously going to be involved in lots of international cooperation and coordination. Though if you've looked at the Financial Times today, there was an interview with Andrea Koskeli, which suggests that the UK CMA is not afraid to depart from what the European Commission decides. And he even questions whether the CMA thinks the Commission was wrong in accepting remedies with regards to Google's acquisition of Fitbit very recently. So there may be divergence there in this really important field. Vertical agreements. Anybody who's studied basic EU competition law will know that so much of vertical agreements has been informed by the single market imperative, things to do with absolute territorial protection and export bans. Now that those issues don't really have much relevance, if any relevance, to UK competition law, is this going to be an opportunity for reformulation more broadly to remove other contentious issues, such as the prohibition of resale price maintenance? So maybe that's another area for divergence. And finally, the block exemption regulations. So these are pieces of law where the conditions are met, grant a presumption of legality. Now, these have been rolled over into the UK as retained EU law to give certainty to businesses, but both the European Commission and the UK CMA are reviewing what to do with them, particularly when the vertical block exemption regulation finishes in a few years' time. And whether they're going to reach the same conclusions on what should happen with these instruments is unclear, particularly in the absence of those mechanisms for coordination and cooperation. So just to briefly summarize, the Trade and Cooperation Agreement has a lot of very admirable principles, commitments to competition policy and cooperation. But in terms of working out the details of how that coordination and cooperation will operate, we're going to have to wait for another agreement coming in the future. And that's it. Thank you very much.
Thank you very much, Ryan. Somehow we ended up where we started. You mentioned another agreement in the future. We started off by pointing out the nature of this agreement as sort of said a part of a process, and the process has just started unfolding, and it may take us in different directions in different areas, and almost all the areas we've discussed, there is in all of them scope for further developments. Let us now move on to questions asked by our audience. The first question is about rules of origin. It is asked by Cheryl Dine, and the question points out the existence of various FTAs negotiated by the UK as first part of the EU. And the question is, how does the agreement address rules of origin for goods? David, would you like to take this?
Yes, thanks, Panos. I should just say I didn't realize we were doing PowerPoints. I was the only one that didn't do one. I didn't get the memo about the PowerPoint. Sorry.
Nothing to feel bad about. Do be.
Okay, that's fine. So the rules of origin question, I was talking about investment, and rules of origin is a trade question, but I'll answer it anyway, since it is so important. There's 15 pages of text in the TCA on rules of origin and more than 70 pages in the annexes. So it's a massively complicated issue. And we've already in the media seen problems about what constitutes a processing for the purposes of establishing origin. It's going to be different things for different kinds of products, very confusing. But I think a couple of points can be made very generally. The rules of origin requirements in the TCA for composite goods, especially cars, are strict. It sets a threshold of 45%. The local content, the non-local content must not exceed 45%, which is pretty high, and it's even more strict if you look at the battery component of cars, which is 30%. So 45% for the main part of the car, 30% is a maximum of foreign component for the battery component of the car. There's been a bit of commentary on how this will disadvantage British manufacturers. But on the point of the question, Cheryl's question was, I guess, talking about the concept of diagonal accumulation. This is when a product which originates from a country with which both of the TCA's parties, that is the UK and the EU, both have free trade agreements, can that constitute domestic content for the purposes of satisfying rules of origin? So a good example here would be apart from Japan. We've got the EU-Japan agreement, we have the new UK-Japan agreement. Well, they're both new, but anyway, we have two agreements with Japan. Can Japanese components constitute local for the purposes of rules of origin? And the answer is no. The TCA did not grant diagonal accumulation. And that is unfortunate. And the other interesting thing is the EU has granted diagonal accumulation for other treaty partners. It didn't do it for the UK. So that was, I would say, a major loss there. And I would say it's a loss for both parties. I wouldn't just say it's a loss for the UK. I think it's a loss for free trade for both parties, which is in the interest of both parties. And I would be interested to know what took place in that negotiation and why the UK wasn't able to obtain that and why the EU was unwilling to offer it. I guess because it sees a potential opportunity to seize manufacturing from the UK. But that's where we're at with that particular issue. But it's very complicated, and it's going to be different thresholds for each kind of product. Thank you.
Thank you, David. Let us move on to a question about data. This is a question by Eva Pandermaat about the EU adequacy decision on data protection for the UK. Whether it will be adopted before the interim regime for data flows expires this June, and what will happen if it were not adopted by then. Elaine?
Yeah, sure. It's the million-dollar question, the great question. Well, it looks highly likely that a decision is being adopted. I mean, it's going through the motions as we speak, and it has been for a long time. But the real question is, for me, is probably not that, but just who's going to challenge it first. So Max Schrems has already said that he's preparing a potential lawsuit. The Libe Commission, the European Parliament, is looking very critically at this, and the Renew Europe group and their capacity to generate litigation, particularly Sophie Neufeld. She's one of the few MEPs that have taken actions not supported by the European Parliament against it. So I'd say there's a lot of attention here from the civil liberty side of things as to how to deal with this going forward, since there are many concerns about the wording of this specific chapter, related to data issues. So not the digital trade stuff per se at all. So yes, I think it's highly likely that it will be adopted. There's a lot of, the 6-month period in the TCA cannot be extended, right? So there's a lot of pressure to do this, and all of this work has been ongoing for a long time, thousands and thousands of pages on this. So it's an enormous amount of work, and it remains to be seen, precisely what the issues are. But I think certainly it will happen. There's a lot of interest in supporting the UK, because this is one of the things they were very well prepared for. In fact, they did a huge amount of scoping work on this, groundwork on this for a long time. The UK was extremely cooperative. So yes, it remains to be seen, but that would be my view.
Thank you, Elaine. moving on to fisheries, a question by Professor Juan Santos Vara. He points out the patchy, very patchy, he says, nature of the dispute settlement system established in the TCA, and he asks whether that might be able to deal with future differences in the area. Jonathan?
Thank you so much, Panos, and thanks to Professor Santos Vara. Yes, I think that this will be a complex issue, as well as we have some DEFRA guidance regarding rules of origin. That was one of the previous questions, and we know that the parties have to comply with these strict rules in terms of processing the product or not, and it will depend whether it's a manufactured good or not. In the terms of what we may see as a result of the future negotiations, it will be aligned with political agreements. And this is a very sensitive issue, as I explained before. For the UK, it relates to sovereignty. For the EU, it's for the market access, basically. And we know that subject to annual negotiations between ICES and also between, with the advice of ICES for sure, and between the UK and the EU, and also the trilateral negotiations with Norway, we will see these numbers vary depending on the advice. So the numbers and this set of numbers that we see for the 5 years and a half are not frozen numbers. They will vary. And what we will see at the end of the agreement is a new agreement. So again, I think that this is what Ryan was stating about future negotiations and the need for more legal instruments in this area. This is not enough, what we already have. It's very unstable and it's only temporary. It works as a patch. So yes, we will see many disputes and or any kind of misunderstandings between the two negotiating blocks, because this is annual, subject to political trends in both blocks. And I think that it doesn't lead to much stability. It may work well for these 5.5 years. The numbers are specific, but subject to the ICES advice. But still, I see the floor for more disputes and having this fisheries committee set up, and even the disputes agreements mechanism in place. So we don't know what the future will bring us, but we should be hopeful for the best and prepared for the worst. Thank you so much.
Thank you, Jonathan. The next question touches on broader themes. It is by Carla Entena. The point is that throughout the whole Brexit process and debate, parliamentary sovereignty was arguably the biggest reason as to why we chose to leave the EU. With the existence of retained EU law, rollover of agreements, and a really narrow definition of level playing field, to what extent do we actually achieve this claim to sovereignty after Brexit? I mean, this is a big question, which in some ways it touches in various aspects we've discussed. Elaine, would you like to start?
Yeah, sure, Panos. I think that's a really interesting question about the extent to which so much retained EU law is the premise, and we see in the TCA. I think it also maybe relates nicely to things that Ryan was saying as well. Like the really huge digitization challenges that lie ahead really stake a claim to what is global Britain, and the EU as, for example, a global data actor as a giant. And trying to engage with this is already looking quite difficult for the UK. In my opinion, it will become something like a squeezed middle power, like Canada, forced to accept in USMCA or in CETA, all different types of agreement standards, being important and significant as a developed economy, but very much squeezed between lots of different types of regimes. And the UK has put a huge amount of its eggs in the basket of Asia, CPTPP going forward. And that raises a lot of questions about its direction as a global actor. So I certainly think that's a really important point. And I think in particular, just as Ryan mentioned, a lot of agencies in the UK are really eager to get a lot of power to try to assert themselves. So I think, there are some who have written about sovereignty in global Britain. Professor Damien Chalmers has written a really interesting piece recently saying that the level playing field provisions have negotiated the UK down, having its sovereignty negotiated by the EU. So it depends on your perspective and how you view this, but I think there's lots of very significant questions to start. Retained EU law has no precedent in any legal order of the same magnitude, and it's going to be very difficult as a middle-sized economy to go out into the world like that. So I think digital trade and data is a very useful starting point for such a question, but of course the answers are simply not known.
And of course, this question about sovereignty, it plays in different ways in different contexts. For instance, the question mentions rollover agreements. One of the complaints that had been raised prior to actually a Brexit was that the negotiation of rollover agreements, the Parliament was left completely in the dark. And we have correspondence between House of Lords committees and the Department for Trade, sort of complaining about the lack of information about the progress of those agreements, as well as the negotiating objectives. And so it's quite interesting that a constant theme of the pre-Brexit debate was criticism against the European Union for lack of transparency in its negotiations. And I would see sort of the same kind of theme when we are negotiating. When we're negotiating rollover agreements, not agreements of sort of major significance which will break new ground. I don't know whether any of the other speakers would like to say anything about this issue. David, could you raise your hand?
I think maybe that's such a general question, an interesting question. I think it.
I don't want to.
Okay, I'm not quite sure what you said there, Panos, but I think you. But I'll continue. I think it's a good point. To what extent has the UK preserved or achieved sovereignty to achieve its objectives, whatever those might be economically? And I think it's maybe the wrong thing to focus too much on these free trade agreements. I know we all study them, I certainly do, and I find them interesting, but the free trade agreements don't ultimately make a massive impact on the GDP of the country. You're talking a couple of percentage points. The real question is, what is the UK going to do at home in terms of its regulatory structure? Is it going to streamline it and achieve these efficiencies that we were always told the EU was preventing us from doing because of its love of bureaucracy? And I, as someone who obviously followed Brexit fairly closely, I always felt that this argument had been poorly made in Britain. It was never really clear to me what exactly post-Brexit Britain was meant to look like. And we know about global Britain and free trade agreements, fine, and CPTPP, and I think those are all good. But how are we going to regulate the economy differently here at home? And it's only now, and I would say in the last couple of months, you've started to see attention being devoted to this issue in terms of questions going out to the public and white papers being launched and consultations, and you start to see the various departments of the UK government finally starting to take a look at this issue. And I don't know, I would suggest looking back at that question, given that the level playing field obligations are narrow, in my view, I see them as being narrow. I think the UK has broad scope to do a lot of what it wants to do. But what does it really want to do? My sense is that I don't see any sign of a Singapore on Thames objective. I don't see unleashing free enterprise. I really don't see that on the agenda. So I'm not convinced that there's going to be a particularly significant departure from the EU anyway, which is again goes back to this question of what was the point of all of it. But I could be wrong, and we will find out, I think, maybe not soon, but we will find out in the next few years. Thank you.
What's very interesting is that there's this distinction between what is it that the UK wants to do and how it doesn't want to do it. There's for a long time there's emphasis on how the UK would like to do things, but there was lack of clarity as to what is it that it wished to do. let us move on to a question about competition law. This is a question by Wolfgang Weiss. He points out that the agreement also addresses state aid, where the UK commits to establish comparative level of an authorization scheme. And the question is, what is your guess insofar regarding coordination or confrontation of the level of protection against competition distortions? I think this is one for, actually, I'm sure this is one for Ryan. Right?
Thank you, Panos. One of the reasons I stayed away from state aid was because of time limitations, but the other reason is it's outside of my research expertise. I don't know a great deal about state aid, to be honest. What I would say, though, is I think more broadly, when we look at competition policy as an area, it's going to be interesting to see what the UK wishes to do with the mixing of competition policy with broader industrial policy, the agenda of levelling up across the UK. This is something which had been in the mix for a number of years now, particularly I think with Theresa May coming to power a few years ago. And the discussion of increasing industrial policy and these wider considerations in public decision making. So although I can't comment on the specifics of the state aid policy, it will be very interesting to see what the UK does with this control of subsidies, and how, even though the UK had been very active in supporting a rigorous approach to the enforcement of state aid at European level, in light of recent developments and maybe a change in the political emphasis, these powers might be used in a very different way to support particular areas and industries.
Thank you, Ryan. Another question by David Walters about mobility and musicians. We've been reading quite a lot about this issue over the last few weeks. He points out that there has been much criticism by musicians of the mobility provisions in the agreement. What does the panel think of the prospects for UK and EU reaching a solution to address the concerns of the music and other touring industries? Which member of the panel would like to take this? Elaine? Oh, I thought you. Sorry, I seem to sort of take the slightest movement of any of our panelists as sort of an eagerness to answer the question.
I don't have any expertise. I was going to offer up Enrico, but that was just through verbal movement.
Well, I mean, it does not have to do with copy. It's more a free movement, you know, of workers issue. What I could say is that here the UK has an interest, strong interest for the big business, creative industry, big creative industry that it has. So British bands, English young bands, they need to tour abroad, and effectively now they have a barrier. So it seems to me, what I have read from the newspaper is that the EU offered of course, a free entry as long as the UK would have reciprocated, but it seems that it was not UK intention to reciprocate. So I guess that sooner or later they will go back to the table, and of course this is a very important strategic area for Britain. The problem is that it is more strategic from Britain than the other way around, because of course EU musicians, they have already EU musicians said they have 26 member states where they can tour. So yes, of course the UK market is now less reachable for EU musicians, but you know, for UK the other way, for UK musicians is quite a barrier. I mean, think about also classical music, or where, you know, the British musicians are very strong. So I guess yes, they will go back to the table to discuss negotiating table, but I'm not sure what will be out there as an outcome.
In some ways, this question sort of touches on the broader issue, which we saw emerging time and time again since the referendum. That is to say, the relative sort of power, negotiating powers of the parties, and how, if there is one issue which is more important to the one party, in this case the UK, how actually it might not emerge as important in the agreement itself. And we've seen this. There were reports yesterday in the FT about statements by the culture secretary asking sort of the fashion industry to make sure that they use their most important and prominent members in order to push the position. The EU didn't go down very well. We were talking earlier about parliamentary sovereignty, and we have a comment by our colleague, Professor of Public Law, Ian Loveland. He says that our end of the withdrawal is pervaded by legislation which gives ministers vast powers, often including Henry VIII clauses, powers to alter all sorts of statutory provisions on the basis of what seem designed to be non-justiciable provisions. So parliamentary sovereignty is only in a limited play here. It's governmental sovereignty, which might be a more apposite, if not acknowledged by the current government description of where we are. There is no doubt that the public law implications of making all this work in the domestic legal order and also filling in the gaps raises all these questions. I don't know whether any of our panelists would like to return to this, sort of this more horizontal issue. If not,
I mean, I think it's a really important point that Ian makes, that you know, it's an extraordinary lawmaking effort. Retained EU law, thousands and thousands of pieces of EU law. It's so chaotic and complicated and badly done. It's a complete mess, that the statute book after this, and it's, you know, statutory instruments being used to do all kinds of extraordinary things, mopping up provisions. I mean, obviously I'm not speaking from a perspective of public law, but it's an extraordinary legislative product. So no wonder that it is complicated. That's not to denigrate the British perspective. I mean, that I think they tried to do their best, but there is no legal genius really behind this question of retained EU law. Like it's a messy, nasty mopping up exercise, and they've given extraordinary powers to government to do this, and it's quite frightening in many respects just how many statutory instruments are actually quite fundamental, or if they use, you know, the scrutiny of these provisions. So, you know, certainly that's just, you know, my own personal perspective rather than any kind of commentary on it. But I think this is a key question that people will need to research and study and work on for some time, you know, in this jurisdiction and beyond. Hopefully, it's an extraordinary reach of executive power.
Thank you, Elaine. Another question on competition law. This is a question for Ryan. This is about online internet sale bans. The question is by Bartosz Osik. He asks whether you think that the CMA or the UK courts might soon diverge from the judgment of the Court of Justice in the Pierre Fabre case, where the total ban on online sales of non-luxury products was found illegal because internal protection rationale became irrelevant.
That's a really good point. So one of the potential areas I mentioned for divergence between the UK and EU competition law development in the future was how the EU's law on vertical agreements was informed in many ways by the internal market rationale. And I suggested that perhaps the removal of this could be the impetus for a more far-reaching change to remove other controversial aspects. What's interesting, though, is that question of internet sales bans, because I would agree that that being presumed to be harmful to competition did at EU level originate from concerns about the internal market, of being able to buy things on the internet, allowing for cross-border trade and facilitating that as much as possible. However, when you review decisions by the UK Competition and Markets Authority from recent years looking at the same practice, they seem to have realigned away from an internal market justification for finding this practice harmful to competition towards one which is more about the value of the internet as a good for competition competition and consumers in and of itself. So just the ability to be able to get things online wherever you are, regardless of different stores, and any other restrictions, that being a reason to find this a harm to competition. So that's one of the interesting ones, because it seems at EU level to be focused upon integrating member state markets. But already there has been movements in UK competition law to adapt this away from an EU focus towards the internet as just a good for consumers. A really good question there.
Thank you, Ryan. We have a couple of questions about sort of the specific forms that further cooperation between the UK and the EU member states may take in different areas. One of them is about competition. This is from a question from Ishani Thakkar. Point out that there have been promises of cooperation and coordination, but also, as Ryan has pointed out, there is likely to be divergence, especially in relation to large aspects of competition law. Do you believe there genuinely could be any sort of future agreement at all, especially because of the increasing Beijing effect and trade agreements with other Asian tech-driven countries, such as India? Because the possibility of an agreement with India is in itself a topic for a webinar, but there we are. Ryan?
So I would say that when we're thinking about future agreements, to build upon what's already there in the TCA, that is largely going to focus upon actual facilitation of enforcement, in particular agreements to allow for the exchange of information, as we see in many other different free trade agreements that the EU has with other countries, and also within specific competition agreements which have been reached between regulators in different jurisdictions. So if there is any agreement, I think it is feasible to see one, but it will be focused upon ensuring effective enforcement when we're looking at mergers and any antitrust investigations with transnational effects. In terms of substantive agreement of the UK and EU saying, well, actually, we'll stick to this is what we mean by a harm to competition. These are the practices we will outlaw. I think that's highly unlikely. That's not to say that informally we may well see competition authorities trying to develop their cases in compliance with each other. But in terms of an explicit agreement reached between the UK government and the European Union saying this is what we mean by competition law and agree to enforce it like this substantively, I think that is unlikely.
Thank you, Ryan. And on this theme of further cooperation between the parties, a question by Professor Katja Ziegler. She points out that since the agreement is generally a thin deal, in particular in services, the UK will want to conclude agreements with the member states of the European Union in at least some areas. What are the chances of agreements between the UK and member states being compatible with the EU external relations competences, given that there is still a hypothetical possibility that the EU or the UK might agree something in the area? And to what extent is there scope for UK and individual member states agreements? David, would you like to say something about this?
Yes, thank you, Panos. It's a really great question. And I think one of the areas where I think we might see progress is in relation to recognition of professional qualifications. So, for example, if you look at the legal services profession as a sector, many of the TCA, as under GATS, many of the EU member states put in a number of restrictions with respect to practice. So in terms of foreign qualifications not entitling to practice the law of that member state. And I think obviously when we had Brexit, the recognition of professional qualifications directive expired, and that means that British lawyers can't practice in member states with their British qualifications. I have a feeling, and I've seen the work that the Law Society of England and Wales is doing, I have a feeling that there will be agreements on that front with individual member states, or the law societies of the member states, to acknowledge things like UK law degrees and training contracts and so on. Now, it won't be across the board, and it's not going to give a right of audience before the ECJ or anything like that. But I think I think there will be progress in that area, but it will be bit by bit over time. And I'm encouraged by the fact that, at least in the sector I'm familiar with, legal services, the Law Society of England and Wales is really pushing for that, and I have a feeling that they probably will make some successes there.
Thank you very much, David. In your answer, you really answered a question which was typed in the moment you started answering the previous question. This was a question about professional qualifications by Daniele Martina. And you illustrated clearly the kind of service that the City Law School provides. Not only do we answer questions asked, but we also answer the questions before they're being asked. I think it is time we stopped here. Thank you very much to our speakers for their concise, succinct, extremely interesting conversations on the hot topics raised by the agreement. Thank you very much to our participants for the very interesting questions and comments. I'm sure that we will revisit many of these issues in one way or another in the future. Well, we shall be here to address them. We hope that you will be here too. Thank you very much and have a good night. Bye.
Thank you, Panos, and thanks to everyone.
Thank you, everybody. Bye-bye.
Bye.